my screen? Perfect. Okay, so thank you. As I said, it's a privilege to present this evening, and this is one of my favorite topics to present on. And I think that the reason for that is because it really ties together a lot of different concepts in the realm of special needs planning. We often talk about public benefits, government benefits. We talk about ABLE accounts. We talk about special needs trusts, and they really all work together. They're all pieces of the same puzzle, and they're interconnected in very many ways. But oftentimes I've found that it's easy to silo each of these issues and to become confused as to how each of the pieces truly interplay with one another. So my goal tonight is to talk about what are public benefits. I'm going to speak specifically about supplemental security income and Social Security disability insurance and the rules about those benefit programs specifically. We're then going to do a deep dive into all the different varieties of Medicaid supports. And then we're going to talk about special needs trusts and ABLE accounts, and again, how they interplay with the public benefit planning. So first and foremost, we begin with what are public benefits? Public benefits are government-funded programs with low income and asset or asset limits that assist individuals with disabilities in the form of either cash or services. And we're really going to talk about that distinction tonight, because some benefits, as it says here, are actual money in your pocket, and other benefits are services and supports that are provided to an individual. And I think that's an important distinction to know what the difference is. So first, we're going to talk about cash benefits, money in your pocket. And those two cash benefits are supplemental security income, or SSI, and Social Security disability insurance, or SSDI. And then we're going to talk about Medicaid as a source of both health insurance, as well as talk about Medicaid and how it can be a portal or a doorway to supports and services for individuals who have disabilities. Okay, so first and foremost, supplemental security income, also known as SSI. This is a cash benefit of up to $841 a month for an individual who meets two criteria. So first and foremost, the individual has to have a disability, and second, $2,000 or less. So starting first with a disability, the Social Security Administration defines disability as some sort of physical or medical impairment that is impacting an individual's ability to work. Now, an individual can still work and qualify for SSI, but the idea is that this disability is impacting their ability to work at a substantially gainful level or earn enough money to really support themselves. So hence supplemental income. This SSI supplements what an individual is otherwise unable to earn in the form of wages. And second, the individual, as I said, has to have $2,000 or less, and that's looking at bank accounts in that individual's name, whether sole or jointly held with somebody else, and making sure that that balance is $2,000 or less. And you'll see here outside of SNT, which stands for Special Needs Trust, or an ABLE account. So later on, again, we'll talk about special needs trusts and ABLE accounts and how they can make money invisible, so that even though we have a very low resource limit for SSI, more money can be held in a trust or an ABLE account, and the individual can still meet this $2,000 asset limit. So importantly, what reduces SSI? There are certain factors that can reduce SSI. So as I mentioned, this is a cash benefit up to $841 a month. So there are certain things that can reduce that $841 monthly benefit. One is if the individual with a disability is receiving free room and board or free food. And this is often the case. People typically apply for SSI when their son or daughter is 18 years old. And the reason for that is because prior to age 18, a parent's money or resources is deemed to belong to the child as well. And with that deeming, the child very often struggles to meet the $2,000 resource limit. At age 18, the child now is a legal adult and the money of their parents is separated from themselves, legally speaking. So we're applying, let's say, for SSI when an individual is 18. Most 18-year-olds are living at home with their parents. So when you go to apply for SSI, many parents are surprised that their son or daughter is not receiving the $841 a month because they're not charging them room and board, or they're providing their food. The reason for this is very dated. Basically, Social Security says, well, we're providing you this cash benefit of SSI, and we think this benefit is enough to pay for your cost of living, to pay for your rent, to pay for your food. Now, nobody can really live off of $841 a month with all of their expenses, food, room, and board. So this is a very dated concept, but it still is the reason that Social Security will say, if someone else is paying for your room and board, we're going to reduce it by a third. In addition, cash payments made directly to a beneficiary when reported to SSI also reduce that child's benefit by a third. And the reason is the Social Security Administration says, well, it's because the child can use that money to pay for food or to pay for rent. And so it's still as if somebody else is covering their food or their room and board. So there's a 1/3 reduction to the benefit. Now, there is a workaround or a strategy for those reductions for free room and board and for payment for food, and that is a rental agreement. So if the parents enter into a rental agreement with the child that basically says the child is going to pay X dollars for room and board, and it will include food, and you present that with your Social Security SSI application, the caseworker will award the maximum SSI benefit as opposed to reducing it by a third. Now, I get a lot of questions from clients about, well, how do I calculate how much I should charge in rent? And I say, you know what, that actually really depends, unfortunately, on the caseworker that you get, in my experience. So in some cases, what I do is say, all right, room and board is going to be $500. And some caseworkers accept and approve that. Others say, no, not so fast. I want to know exactly what all of your household expenses are. I want to know what your mortgage is, what your utility payments are. And then I want to know how many people are living in the house, how many adults. And we want to divide that out so that the child is actually paying their equitable share of the actual costs. So it really depends on what your caseworker requires. But we can talk about that in a little greater detail later on. The last thing that reduces SSI is child support. So if there's a parent that's paying child support to a child, that will reduce an SSI benefit. However, if as part of a divorce agreement, those payments go to a special needs trust, particularly a first party special needs trust, that can avoid a reduction of SSI. So if somebody is thinking about getting divorced and they have a child with a disability, it's important to consult with an attorney versed in public benefits so that you make sure that whatever that divorce agreement isn't going to offset benefits like SSI. The other solution I said here is an ABLE account. So in a case, let's say, for example, where a caseworker says you have to calculate your rent based upon all of your household expenses. What if those expenses come up to be $900 a month, let's say, and the child is only getting $841 a month? You're in a position where the child doesn't have enough money to pay fair market rent, so they're not going to get the full SSI benefit. So in some cases, we use an ABLE account as a workaround where a parent can contribute extra money to the child's ABLE account, which the child then can use those resources to pay to cover the shortfall in rent. And you'll see later when we talk about ABLE accounts exactly how that will work. But the key is that, once again, ABLE accounts and special needs trusts are tools that can help to make sure that someone is getting the maximum SSI benefit. Okay, so I've got a couple case studies to try to allow us to test our knowledge of SSI. So first, Grace is an 18-year-old young woman with an intellectual disability, and she has never worked. Grace has $100 in a checking account, and she applied for SSI. Her application was granted. So the question is, well, why? And we always have to go back to that two-pronged test. An individual is eligible for SSI if, one, they have a disability. Yes, Grace has a disability. Her intellectual disability was deemed by Social Security to impact her ability to work. And two, she has resources less than $2,000 because she only has $100 in a checking account. So she is eligible for SSI. The second case study is, again, we have Grace, who's living at home with her parents rent-free. Her parents buy all of her food. Is she eligible for SSI? Yes, because number one, she has a disability. And number two, as I mentioned before, she only has $100 in her name, so she meets both of the prongs, $2,000 or less in a disability. So she's eligible to receive SSI, but she's not going to receive the full $841 a month. She's only going to receive about $555 because she's receiving free room and board. Her parents are covering those expenses. So her benefit is reduced by 1/3. The solution, as we just discussed, Grace can create a rental agreement with her parents so that she becomes eligible for the full SSI benefit. And last but not least, Grace has $5,000 in a checking account. She applies for SSI. Her application is denied. Yes, she has a disability, but does she have less than $2,000 in her name? No, she has $5,000. Solutions: she can put the extra money into an ABLE account or a first-party special needs trust, as we will once again speak about later on. Okay, so we just talked about supplemental security income, or SSI. Now we're going to talk about Social Security disability insurance, or SSDI. And although there's only one letter differentiating SSI from SSDI, there actually are some very significant differences between the two. And those differences are very impactful in the realm of public benefit planning. So it's important to understand what the distinctions are. So there's two ways that you can get SSDI. One is really through your own work record. So this would traditionally be an individual that's working, paying into Social Security as they work, and Social Security tracks everybody's work records, and they know how much you've contributed every year. And Social Security basically ascribes what are known as work credits to individuals. So if an individual works long enough and earns enough work credits, they are no longer able to work because of their disability, they would qualify for Social Security disability insurance based on their own work record. Now, there are some individuals with disabilities that actually get two payments from Social Security. One is Ssdi based on their own work record, and the other is SSI. So if somebody's Ssdi payment, let's say, is only $300, and the maximum SSI benefit, like we just talked about, is $841, Social Security is going to say, okay, we'll send you an SSDI check of $300, and then we'll send you an SSI check for the balance to bring you up to $841. So some people get two different checks. The other way that an individual can get SSDI, and this is really, really critical, is through a parent's work record. So if there is a child or an adult child who has a disability that started before the age of 22, and their parent who paid into Social Security retires and begins drawing on their benefit, becomes disabled themselves, so they have to stop working after having paid into Social Security due to a disability, or they pass away, that child who had a disability starting before 22 is entitled to 50% of the parent's Social Security benefit if the parent retires or leaves work due to a disability, and it becomes 75% when the parent passes away. In a case where there are two parents, the child will always be eligible for the higher benefit of the two. So if the lower earning parent retires, that the child will get half of that parent's benefit. And then if the higher earner later retires, let's say 2 years later, the child will get converted to the other parent's 50% of the other parent's benefit. The way that this is ultimately elected is when a parent retires and they fill out the Social Security paperwork, there's a question that says, do you have a child with a disability? You'll say, yes, I do. And then it will search the Social Security records to find the child in the Social Security system who we presume at that point in time should be receiving or should have been receiving SSI, Supplemental Security Income, because remember, you can apply as early as age 18, well, sooner, but usually you apply at age 18 due to that resource limit. So other important considerations is that the portion of the benefit that the child gets does not reduce the benefit that the parent receives. It's in addition to what the parent receives. In the middle of the screen, you'll see that regardless of whether you get SSDI through your own work record or through a parent's work record, there's a couple of things in common. Number one, no asset limit. So with SSI, we were talking about how an individual is only eligible if they have $2,000 or less to their name. Whereas SSDI is what's known as an entitlement, kind of like retirement, Social Security retirement. You paid in, you earned it, you get this benefit. So regardless of what's in an individual's bank account, they would still be eligible for SSDI as long as they meet the disability criteria of a disability starting before the age of 22. And I also want to mention that I do have clients that come to me and they say, you know, they've had this lifelong disability, but they have never received Social Security benefits. You don't have to apply for Social Security before 22 in order to qualify. You can be 35, you can be 40 when you apply, but you have to have the records showing and demonstrating that the disability started before the age of 22. Back to the middle, there is no income limit for Social Security disability insurance per se. The only income that the Social Security Administration cares about for this benefit is earned income, which is wages. And for 2022, the substantial gainful activity level, or SGA, is $1,350 a month, and that's gross. So what this is saying is that Social Security, as we talked about earlier, links your disability to your ability to be substantially gainfully employed. And they actually put a number on that. And that number in 2022 is $13.50 a month. So if you have a child with a disability that's earning above and beyond $13.50 a month, they may lose their eligibility for Social Security disability insurance because the Social Security Administration is going to say, you might have a medical impairment, but we don't see the connection between that impairment and an impact on work because you're able to earn over this level. Now, there's some exceptions here where their Social Security has certain programs, trial work periods, ticket to work, and other ways to offset or reduce earnings or to be able to continue a benefit for a certain period of time if you're earning above $13.50 a month. But this number should really be looked at as a line in the sand. And it's one that everyone should be really critically conscious of, because there can be really big impacts if an individual is consistently earning over that figure because of what they're potentially losing, meaning the ability to have 50% of a parent's benefit and 75% when they die throughout their lifetime. So it should be, not that it shouldn't happen, there should just be a conscious choice as to whether the individual truly does or does not need the Social Security benefit. And lastly, after 2 years of receiving Ssdi, an individual gets Medicare, and that's huge. Medicare is much more widely accepted as a source of health insurance than Medicaid. There's many more doctors that accept Medicare than accept Medicaid. So it can open up a provider list for individuals. And it can also help to offset the cost of healthcare in a way that has less financial restrictions than health insurance through Medicaid, which we're going to talk about next. But first, some case studies. So we have Mark, and he's 24, and he has autism, and that was diagnosed when he was 16. He has never worked. His dad retired and began receiving $2,000 a month of Social Security retirement. Is Mark eligible for the Disabled Adult Child Benefit? Yes, he will get $1,000 a month, which is 50% of his dad's benefit, because Mark meets the Disabled Adult Child rule. He has a disability that started before the age of 22. Now we have Mark once again, who's never worked. His dad retired and began receiving the $2,000 a month, but Mark has $20,000 in his bank account. Is Mark still eligible for this benefit? Yes. Remember, this is Ssdi. This is not SSI with that $2,000 resource limit we talked about. So Mark still gets half of his dad's benefit, $1,000 a month, because his disability started before 22. No asset test for Ssdi. So Mark doesn't have to touch that $20,000 in his account. He still gets Ssdi. Lastly, Mark is 24, autism, all the same facts. Mark's dad is receiving $2,000 a month through Social Security. Mark is working and he's earning $4,000 a month. Is now Mark eligible for the benefit? The answer is no, because Mark is not considered to have a disability that's impacting his ability to work, because he's earning above that $13.50 a month, the substantial gainful activity level. Yes, Laura, did you have a question?
We do have a couple of questions in the chat. The first question is, can a child still receive SSI if they're 18 and still in high school?
Yes.
Okay. And the second question is, can you please explain the case study 2 again?
For Ssdi?
Yes.
Sure. So this is really drawing the distinction between SSI and Ssdi. So if you recall, I'm going to go back to the SSI slide. So SSI has two rules. One is that you have to have a disability, and two, you have to have $2,000 or less. For SSDI, there is no asset test. So it doesn't matter. There's no $2,000 or less for this benefit, no asset test. So in case study 2, Mark has never worked. His dad retired and began receiving $2,000 a month. Mark has $20,000 in a bank account. It doesn't matter whether he has assets or not for this benefit, because there's no asset test for SSDI. Now, if Mark had $20,000 in his bank account and he applied for SSI, he wouldn't be eligible. But this is a different benefit with a different set of rules. Any more questions? Okay. All right, so now we are on to Medicaid, Husky. So the Husky program in Connecticut is a labyrinth all unto itself. So my goal is to try to demystify what the different Medicaid Husky programs are, what they do, what the eligibility rules are, and when you might need to access them. So Medicaid is a government-funded program, and it's actually funded by both the federal and the state governments for health insurance and or services and supports for eligible individuals. And this is a really critical distinction. Again, what we're going to talk about first is health insurance. So there are times when individuals are maybe not receiving health insurance through an employer because they're not working, or their employer doesn't offer health insurance, and they meet certain income or asset limits that the state has set out for the Medicaid program, so that individuals are able to get their health insurance through the government. So there are 3 main forms of Medicaid. We have Husky A, Husky D, and Husky C community Medicaid. Now, what's really important is that when we talk about Medicaid as a source of health insurance, all of these different forms of Medicaid, Husky A, Husky D, or Husky C community Medicaid, all lead to the same place, meaning they're all the same health insurance plan. So it doesn't matter whether you're on Husky A, Husky D, or Husky C community Medicaid in terms of what your health insurance plan covers. So I like to think about these as all just separate doors to the same health insurance plan. So it's going to be the same coverage, the same dental coverage, the same medical coverage, the same prescription coverage. The difference is just which door do you fit through, because not everybody fits through the same door, because there's different rules for the different Husky programs. So starting with Husky A, this is health insurance for low-income parents or caregivers and their children up through the age of 18, sometimes through the age of 19, depending on when that child is going to graduate from high school. Husky A has an income limit only. There is no asset limit for Husky A. We're just looking at income. And what the state is looking at is income based upon your household size. So if you're a parent and you have 2 children, you've got 3 people in your household. So there's actually a really helpful chart on the state's website that shows what the income limits are based upon how many people are in your household. And I put the range here. So the range is from a 1-person household up to, I don't remember what it goes up to, maybe 8, 6. So it's $1,718 a month gross to $4,784 a month gross. And that again is just income. There's no asset test for Husky A. So if a parent has low income, they can get health insurance for themselves and their children as long as they meet these income limits. And that their form of health insurance is going to be called Husky A. Somebody can also be on Husky D. So if you don't fit in the Husky A door, let's see if you fit through the Husky D door. Health insurance for low income adults ages 19 to 64. So here, like with Husky A, there's only an income limit. Once again, there's no asset test. And the income limit, like with Husky A, is going to vary based upon your household size, and it ranges from $1,482 a month to $4,092 a month of gross income. Last but not least, we have Husky C Community Medicaid, and this is where some people fall who are age 65 and older or who have a disability. And for Husky C, we have both income and asset limits. Remember, Husky A and D, we're just looking at income limits. For Husky C Community Medicaid, we have an income limit, and it's either $894 a month or $1,005 a month, and that depends on what part of the state you live in. If you're in the Fairfield County area, for example, it's going to be the higher income limit. But the asset limit is $1,600 in order to access and get Medicaid through Husky C. So some people can fit in multiple doors. So someone with a disability, let's say who's 17, can get to Medicaid through Husky A, because if they have a parent who's caring for them and they meet the income limits, they can get to Medicaid through Husky A. But there's some people that only fit through one door. And so that's where we need to pick which door somebody fits through. Last but not least, I do have here that Husky A, Husky D, and Husky C are all portals to Community First Choice. Community First Choice, we're going to talk about more later, is a program that provides services to people with disabilities. So right now, what we're talking about in this chart is health insurance, just health insurance. But you can also get the added bonus if you meet extra criteria that we'll go over to access services through Husky A, Husky D, and Husky C Community Medicaid.
We do have a couple of questions about Social Security and Ssdi. Do you want to go through this and review afterward, or do you want to review it now?
I'll answer them now.
Okay, great. Let's see. So how does the parent ask or apply for retirement benefit? Does it still require a rental agreement for the child?
No, good question. So in addition to there being no asset limit, there's no possible reduction to the benefit. So a child whose parent retires, and if that child had a disability that started before the age of 22, they're going to get half of their parent's benefit. It doesn't matter whether or not that child is paying rent, whether someone else is paying for their food. None of that matters for Ssdi. So rental agreements go out the window when we're talking about Ssdi.
Okay. Now we had another question. If my cursor's not working with me too well, so see if I can get it. How does the parent, oh yeah, how does the parent ask or apply for the retirement benefit? Nope, I just asked that one, I apologize. If the parent retires and receives Social Security, can the disabled child apply for Ssdi retrospectively?
If the parent, yeah, so I think the question is, if a parent retires and maybe the child wasn't in the Social Security system yet, or the parent didn't indicate that they had a child with a disability, can the child later start to recover through the parent's work record? And the answer is yes. And I've had that happen. That's one of the things I screen for with my clients is, they'll come in and I'll be talking to them and they'll talk about a parent that passed away. And I'll say, well, did they pay into Social Security? And they said, yes, of course they did. And I said, and when did your disability start? And if it started before age 22, they're able to go ahead and apply for that disabled adult child benefit.
Okay.
I have a question.
Questions? Okay,
I have one. Can I read to you?
sure.
How is the lease legal if your child is severe disabled? Would you hire a lawyer?
So that's a good question. When we're talking about issues of capacity, oftentimes if a child doesn't have the ability to make decisions themselves or to enter into a legal contract, oftentimes that child will have the parent appointed through the probate court to act as their guardian or as their conservator. So that's someone to make decisions on their behalf because the child has been deemed not to be able to make those decisions themselves. And in those cases, I have done rental agreements and I submit them to the probate court for approval so that the parent gets approval to basically take payment from the child in their role as the conservator or the guardian, depending on the situation.
We have another one. Do you want me to ask you now?
Sure.
It's back to Ssdi, if that's okay. If I retire and begin receiving a pension for my employer, but wait to start collecting Social Security benefits at a later age, will that impact when my son can start receiving Ssdi?
Yes, through the parent's work record, when a parent retires, the benefit for the child only begins when the parent starts drawing on the Social Security benefit. So the turning point is not so much whether the parent is retired as whether they're drawing on their retirement benefit.
I have two more. I don't know if you want me to read to you.
Oh, that's fine.
For Ssdi through the child's own work records, what is the requirement for enough work credits?
I don't know that off the top of my head because it does depend in some ways on the child's age. What I would say is you can send me an email, that person can send me an email and I will send them the answer. Or you can go on the Social Security's website and they have little pamphlets. So even if you just Google Social Security disability insurance work credits, it should come up and it tells you there's a chart that talks about based on your age, how many work credits and how many work credits you can earn in a year and whether they have to be consecutive years or not. So there's some layers of complexity, but there are good guides on the Social Security website.
Thank you. And one more. I applied for SSI for my son who has an intellectual disability and was denied. Is there assistance with the appeal process?
Yes, so unfortunately, some people are denied the first time they apply for SSI, and you can file an appeal and choose whether to file an appeal individually or with an attorney. And usually those cases when you appeal are granted. If an individual is interested in hiring an attorney, attorneys generally are not, they can't charge you a separate fee. They're going to get paid based on whatever is, if the appeal is successful, based on whatever is owed backwards to the child from the date of denial through the date that the appeal is approved. I personally don't handle Social Security appeals, but I certainly do have attorneys that I work with that do. So if people are looking for recommendations, I'm always happy to make some connections. And then Caroline, did you have a question?
So I am a school teacher, and teachers in Connecticut don't receive Social Security. We contribute to a government funded pension instead. So when I retire, even though I've been working full time, how would my son receive a benefit that I'm not going to receive?
Unfortunately, he won't, because you wouldn't meet this rule through Social Security. So his Social Security pathway would either be Ssdi based on his own work record or SSI. Okay. So back to the land of Medicaid. So we talked about Husky A, Husky D, and Husky C as sources of health insurance, and also being a possible portal to services through Community First Choice, which we'll talk more about in a moment. I also want to mention Husky C, Medicaid for employees with disabilities, and Husky C, long-term care. So there's multiple forms of Husky C. We just talked about community Medicaid. If somebody has a disability and they're working, then they can access Medicaid for employees with disabilities, which again is the same health insurance plan. It's not a different health insurance plan than Husky A, D, or community Medicaid. The benefit is really just that you get a higher income and a higher asset limit. So instead of the income limit being around $894 or $1,000 a month, it goes up to $6,250 a month. And the asset limit goes up from $1,600 to $10,000, plus retirement accounts are exempt. I do want to keep everyone to keep in mind that when I talk about asset limits, and even when I talk about certain income limits, we can always use ABLE accounts or special needs trusts to keep extra money above those low limits, which again, we will continue to talk about. And lastly, we have Husky C, long-term care. So this is where we really start to talk about services. Long-term care connects people to either skilled nursing services. So this is actually in the context of people who need care in a skilled nursing facility. So elders that are potentially applying for Title 19 Medicaid. This is exactly what that program is. Or individuals accessing waiver services. And I'm going to talk on the next slide about what waiver services are. There is an income limit of $2,523 a month and an asset limit of $1,600. Again, we can use trusts and ABLE accounts to exempt additional resources above those limits. Both Husky C, Medicaid for employees with disabilities, and Husky C, long-term care can serve as portals to Community First Choice or waiver services, as we will talk about now. So a waiver program, waiver is kind of a confusing word. Waiver basically says that traditionally Medicaid was only provided in an institutional setting. And over time, the laws basically changed. People realized people are better and best served in a home and community-based setting. So waiver is really saying we're waiving all of those rules that apply to institutional Medicaid, and we are applying different rules so that Medicaid services can be provided in a home setting. So anytime you talk about a waiver, you're talking about someone who's living in their home with a parent, at home by themselves, in an apartment, a condo, someone who's in the community, so to speak. So there's different Medicaid waiver programs, and these are really similar to all of the different doorways that we talked about, Husky A, Husky D, Husky C. that there are different doors and not everybody fits through every single door. So you have to look at whether you fit through a door. And unlike those Medicaid doors, which all lead to the same place, waivers lead to a place that is specifically tailored to the needs of the people who are coming through the door. So I'm going to start on the left column. These are all the waivers that we have in Connecticut. Waivers are, in order for Connecticut to offer a program or services or supports to certain people, we need to get approval through the federal government. So these are all the programs that we've gotten approval for and which are provided on an annual basis. The first is the personal care assistance waiver. This is if somebody needs help with activities of daily living, like bathing, dressing, eating, moving around, using the bathroom, things like that. And they require somebody to physically assist them with those things. For the personal care, the PCA waiver, there is a waiting list generally of about 2 years, unless somebody is going to be transitioning onto that waiver program from a nursing home. Then you can skip the waiting list. The Katie Beckett waiver is a program for individuals through the age of 21 who have severe medical complexities. There's also a waiting list for the Katie Beckett program. I'm not sure how long it is now, but I believe it's probably at least 10 years of a wait. There is a mental health waiver. So this is for individuals that have certain mental health or psychiatric diagnoses. And this program allows the individuals to access case management services and different oversight and programs that are tailored to their mental health needs. We have waivers through the Department of Developmental Services, or DDS. And these waivers are provided to people that have an intellectual disability, which is an IQ of 69 or lower. And the different waiver programs include employment or day supports. So when an individual graduates from school, now you can go to school through 22, when they graduate, they would get funding basically to provide for employment services or day program services. And then we also have the individual and family support and comprehensive support waivers, which are really looking more toward residential services, in-home supports for people with intellectual disabilities who meet certain criteria, including that right now that their needs are pretty acute because there's long waiting lists for residential services. And I hate talking about waiting lists, but it is the reality. And speaking of waiting lists, probably one of the worst is the autism waiver. There's only 100 spots available for this program. It's services for people with autism. Because there's only 100 spots right now, the waiting list is potentially over 100 years because of the severe need. But I always tell parents, apply for the waiver program no matter what, because what's restricting availability is how many spots there are. And with legislative advocacy or changes to the program, if we get 500 spots instead of 100 spots, you're going to want to be in line when that list starts going more rapidly. The Connecticut Home Care Program for Elders is home care for individuals that are 65 or older. So instead of having long-term care in a nursing home, you can get that care at home. And lastly, we have the Acquired Brain Injury Waiver, which is a program for people that have brain injuries, which also has a waiting list of a couple of years unless you're accessing it through a nursing home. All of these Medicaid waiver programs that I just mentioned, the only way to access them is through either Husky C Medicaid for employees with disabilities in some cases, or Husky C long-term care. So that's really important. If you are looking to access waiver services, you can't be on Husky A, you can't be on Husky D, you can't be on Husky C Community Medicaid. So a lot of times If someone, for example, has an intellectual disability and they're enrolled in DDS and they're about to graduate from school, you might have to change your Medicaid coverage because that individual might have been on Ssdi. They might have been on health insurance because they were 18 or 19 or 20 years old and they met low income limits, but now that they need to access those DDS services, they need to jump over to this form of Medicaid. So oftentimes what we're looking at is different income or asset limits that are going to apply. All right, so I mentioned community first choice. Community first choice is a source of supports and services for individuals in Connecticut. And it's not a waiver program. You didn't see it on that prior slide. And what's great about that is when I talked about all those waiver programs, I was talking a lot about waiting lists. Community first choice does not have a waiting list. Technically, you might have to wait a period of time to get assessed for it, but there's no limitation on the spots that are available. So you're not waiting in line until a spot becomes available. If you meet the eligibility criteria, you're going to be enrolled in community first choice. So what is it? Well, ultimately what it is, it's a budget that the state awards to an individual who has a need for hands-on assistance with activities of daily living, like bathing, dressing, transferring, using the bathroom, or eating, or they have an unmet service need. And this is traditionally where people with disabilities fit in. So the Department of Social Services that administers this program says if you have an intellectual disability, or if you have autism, or really any sort of disability, regardless of the label, that's impacting your ability to live independently, then you may be eligible for this program. And someone will come, you initially fill out a screening tool that basically talks about where you're independent, where you're dependent, and someone will then come out and do an assessment, ask a bunch of questions about where your level of need is. And based on that, they will assign a budget. So let's say that it's $30,000 a year. That's money that you get every single year to pay for caregiving supports. And those caregiving, or that budget rather, can be used for people that you hire and you manage, you being the person with a disability, or if they're not able, a parent or another person on their behalf, hiring people, deciding what their hours are, what they do. So it's a self-managed program. The state of Connecticut doesn't give you the money. What they do is there's a company called Allied that will manage the money for you. You tell them who they're paying, how much they're paying them, and you sign off on the timesheets, and they take care of the rest. You must be enrolled in Medicaid in order to access community first choice. So remember, I talked about Husky A, Husky D, Husky C are all portals to community first choice. So if somebody is on one of those programs and they have a need for hands-on assistance, or they have an unmet service need, they can apply for this program to see if they qualify for a budget for services. Okay.
I do have a quick question. Would you suggest an elderly person apply for a community first choice budget?
That depends. So if someone's over the age of 65, that's considered elderly in terms of meeting the criteria for the Connecticut Home Care Program for elders. There is no there is no waiting list for the Connecticut Home Care Program for elders. And just like with community first choice, in most cases, I would say an elder is going to be applying for the home care program for elders, but there are some cases where it might make sense to apply for community first choice, and that those factors are really case dependent. So I would say it's worth talking with an attorney about the pros and cons of both options, but I'd say probably 9 times out of 10, you're going to ultimately apply for the home care program for elders.
Okay, There was a quick question about the IQ for DDS, if they would qualify as 71. In my experience, it's been a pretty hard line at 69. Very rarely have individuals with an IQ of 71 received DDS services, unless their functionality and their adaptive skills was extremely low. I don't know if you've had any different experiences with someone with an IQ of 71 receiving DDS services. That's the Department of Developmental Services, just to be clear.
Right. So the IQ cutoff score, unfortunately, is a bright line rule. Yep. DDS is very strict in enforcing that bright line rule. That being said, there have been cases where individuals have received maybe even multiple IQ scores. One might be 71, but then you have two that are 67 or 69. And then it becomes about appealing the eligibility denial and really proving your case with a really good psychologist that can talk about why the 71 score isn't correct and why the other scores are really more accurate. Certainly it's an uphill battle, but it's one that can be waged. And in my opinion, DDS services are robust, they're lifelong, and they're worth fighting for if you're in a position to be able to do so. Otherwise, if you're not, because you truly don't meet the criteria or you've lost an appeal, the best path forward to me is community first choice to get services. Okay. So we've talked about, to recap, we talked about cash benefits. We talked about SSI and Ssdi. We've talked about Medicaid. And when we've talked about SSI and we've talked about Medicaid programs, we've talked about income and asset limits. And so the question is, well, how does that all fit in with special needs trusts? And the reason I start with public benefits is because the public benefits are the why, the special needs trust is the what. So you need a special needs trust because you are enrolled in or you plan to enroll in public benefit programs with low income or asset limits. So the law basically says, we recognize that there are people out there that have needs and that they need to access these public benefit programs. And if we actually enforced these low eligibility rules, they'd be impoverished and wouldn't be able to basically sustain their ability to live. So let's allow people to still access our government programs while having more money than what the eligibility rules allow. But we're not just going to let them have their money in their bank account. It has to be held in an account like a special needs trust or an ABLE account that follows the rules that we set. So a special needs trust, we have our charming friend, Harry Potter here, with his invisibility cloak, because a special needs trust is a legal tool that makes income and assets invisible for the purposes of meeting the low income and asset limits of benefit programs. So we know Harry's under the cloak. We know that that is just a trick hiding him. And in the same way, the state of Connecticut or Social Security knows there's money in the trust. We're not lying. We're not failing to disclose it. We're telling them, look, there's money in the trust. But because of the language that is in the trust, because we followed the rules that the law has given us, it makes the money invisible. And so the government will treat it as such. There are two main types of special needs trusts. I always say this, there's actually really three, but one type of special needs trust is called a pooled trust. It's the only type of special needs trust you can have if you're over the age of 65. And that's typically the context in which it's used for people that are older to help meet income or asset limits for their Medicaid services. So in the disability realm, we're really generally just talking about two types of special needs trusts. And those are a first party special needs trust and a third party supplemental or special needs trust. The words supplemental and special are interchangeable. So you'll notice here that in comparing the two trusts, I bolded the first and the last bullets because these are the ways in which first-party trusts and third-party trusts are different. And in virtually every other way, they're the same. So first, a first-party special needs trust holds the money of the individual with a disability. So if Harry Potter has a disability and he has wages, or he has accumulated Social Security benefits, or he wins a lawsuit, a medical malpractice claim, or a wrongful death claim, if he wins any sort of lawsuit, all of those types of things are Harry Potter's money. They belong to him. Even if it's not in his pocket yet, he's legally entitled to that money. So in order for him to make his own money invisible, he can put it into a first-party special needs trust. Let's jump over to the third-party supplemental needs trust. This trust holds money of people other than the person with the disability. So Harry Potter's money can't go into a third-party trust. Other people's money can't go into Harry Potter's first-party trust. So an example of other people's money would be parents. So Harry's parents, before they passed away, created a special needs trust for Harry Potter, knowing that he was likely going to need benefits during his lifetime. And they funded it maybe with life insurance, maybe with other assets that they owned. So other people's money went into it. Let's say Hagrid wanted to make a donation or a gift to Harry during his lifetime or in his death, he could also contribute to a third-party trust for Harry. So as long as it's other people's money, that's okay. It can go into that third-party trust. So the two things then that we're going to talk about that both of these trusts have in common is that the money has to be managed by a trustee. The trustee has to be somebody other than Harry Potter. The beneficiary of the trust, the person with a disability, can never be the trustee. So this is one of those rules that makes a special needs trust work, is that somebody else has to manage the money. The money has to be used for the benefit of the person with the disability. So the money has to be used for Harry Potter's benefit. There is some flexibility. So let's say that the beneficiary wants to go on vacation and they're not able to go on vacation themselves because of their disability. They need a companion to help them or a personal caregiver. The trust can pay for the services of that individual because the person really needs that other individual to be able to go on the vacation at all. So there is some flexibility there. The other thing these trusts have in common is that the trustee has the absolute sole authority to say yes or no to a distribution. So if Harry wanted $50,000 because he wanted to go buy a really, he wanted to buy a nice car, the trustee could say, no, that's really not a good idea. We're going to deny that request. And Harry has no recourse because the trustee has the absolute authority to say yes or no. And that again is what makes this money invisible. That's what makes a special needs trust work, is that that trustee has that sole authority. Now the trustee can be a parent, it can be a sibling, it can be a friend, it can be a professional trustee. So all of those things depend upon the particular family and their circumstances and their circle of supports. Sometimes a special needs trust, a third-party trust, can be set up in someone's will, which means that the court will always have ongoing oversight of the trust. Or it can be its own separate document, which means that a court is not involved. So that's a good thing to talk about with an attorney when creating these documents, is to make sure that you know whether or not the court is going to be involved. And many people don't want the court to be involved, meaning that the trust would not be in their will. So lastly, The ways in which these trusts are different is that for a first party's trust, when the trust ends, when the person with the disability dies, the state, any state that provided Medicaid benefits is the first beneficiary. So this is what's known as the payback provision, so that when someone or a state has provided medical benefits, they get paid back from whatever is left in the trust up to the amount of benefits that were provided. And if there's anything left after that, that leftover money would go to other named beneficiaries, maybe siblings or other children. If there's nothing left in the first party trust when the individual dies, the state doesn't get anything. So the state is only paid back out of what's left. For the third party trust, the state is not a beneficiary at all. And this is where the importance of planning comes into play, is that if parents or other family members properly direct an inheritance to a third party trust, they've made sure that no matter what, the state of Connecticut can never put a claim against that property. So those are the differences between the first party trust and the third party trust. And sometimes people say to me, well, which one do I need? And I say, it's not an either or. We have to look at whose money needs to be invisible. If it's other people's money, you need a third party trust. If it's the individual with the disabilities money, you need a first party trust.
We do have a question. How is a special needs trust different from a discretionary trust with restrictions on payment for services which would be provided by a government program?
I would have to look at the trust that that person is referencing, but oftentimes, so a discretionary trust and a special needs trust are very similar. Usually the distinction is whether or not there's special needs language in the trust to talk about a disability or not. But in many cases, if it's properly drafted, a discretionary trust can make money invisible for the purposes of benefit programs in the same way as a special needs trust. But as I said, I'd be really careful about it and make sure that an attorney reviews it and make sure that they confirm that.
I have another question in the chat too. Question about acceptable documentation for autism. The student is in 6th grade. The school psychologist identified the disability as ID. The independent evaluator identified the disability as autism. When should the parent start the application process, and which disability is the acceptable one?
So it depends on what you're referring to in terms of what an individual is applying for. So disability for special education services is going, and what classification someone has on an IEP, for example, is going to be different from a disability classification for Social Security, which might be different than the classification you're looking for from the state to apply for a Medicaid program. So the answer is it ultimately depends potentially, but if for the purposes of Medicaid services, an individual is trying to choose between autism or intellectual disability, there are more accessible services for intellectual disability, provided the IQ is 69 or lower. And you can apply for those DDS or Autism Waiver services really at any point in time. I think usually they want you to wait until someone is at least 8. Or you can apply sooner, but you might have to reapply when they're age 8, because that's kind of the shift into, I don't want to say adult services, but the shift out of the birth to 3 type of services.
We have a couple more, if you don't, can I keep going?
Sure.
Okay. At what age of special needs child should we see a lawyer to help set up those trusts?
I always say, so for the third party special needs trust, if you have an indication or a thought that your child might need these benefit programs, I would say that they should come and see an attorney now, because you just simply don't know if something happened to both parents in an unexpected way, then you want to make sure that whatever was intended for that child is protected. So if they need benefits, that money is protected. And really, most importantly, you've protected the money so that the state of Connecticut can never have a claim. Because if parents, let's say something catastrophic or unexpected happened to parents and their child inherits the money outright, we can make the money invisible, but we can only make it invisible now with the first party trust, of which the state is the first beneficiary. So the third party trust really operates like a safety net. We don't think we're going to need it for a really, really long time, but if benefits are an option, let's put it in place. The other thing that I talk to families about is it is possible to put an early termination clause in your third party trust. And I do that in cases where the child, families just don't know. A child might be independent, but they also might need benefits. So I say, let's create a special needs trust for them as a safety net, not as a ceiling, but as a safety net. And if they ultimately are independent, financially, they don't need benefits, there is a way in this trust for it to terminate and for the money to go to that child outright. So that also gives a little flexibility so parents don't have to know for certain whether benefits are needed to have the trust in place.
We have several questions, but I'm not sure if you want to address ABLE accounts first and then go back to the questions, or?
Yes, let me talk about
Okay.
ABLE accounts very briefly. That's my last slide. And then we'll do questions. All right. So an ABLE account is kind of like a hybrid between a first party trust and a third party trust. And it's a hybrid to the extent that either the person with a disability can put money in or other people can put money in. Whereas with those two trusts, remember, it's really separate and distinct in terms of whose money can go into each. An ABLE account is a tax-advantaged bank account for someone with a disability that makes the money invisible, just like the special needs trust, to meet low asset limits of public benefit rules. Tax-advantaged means that whatever money is in the account is going to grow income tax-free. And likewise, distributions from the account are going to be tax-free. The account is for an individual with a disability that started before 26. You can establish an account in any state that's open to non-residents. Does not need to be a Connecticut ABLE account. Connecticut does now have an ABLE account, has for a couple years now. Connecticut is pretty stringent in its enforcement of certain rules about who can open an account and manage it. So some people have had a little bit of inflexibility with Connecticut accounts. I always talk to clients about finding the account that kind of works best for you. And I've heard a lot of positive feedback from clients on the Ohio ABLE account most frequently. Ohio was the first state to offer ABLE accounts. And so I think that they maybe have their procedures down in a way that works for families. But certainly you can look at any state. There is a website called ablenrc.org, ablenrc.org, where you can go and compare ABLE accounts for different states to find the one that you think is best for you. The person who creates or manages the account is either the person with a disability, or it can be their parent or guardian or someone creating it on their behalf if the individual is not able to create it themselves. There are contribution limits to the account. So unlike a special needs trust, you can only put in $16,000 per year from any and all sources. So, however, you can add more if the individual is employed. They can contribute some additional funds subject to certain rules. The funds have to be used similar to a special needs trust for the benefit of the individual with a disability. The rules say it has to be a qualified disability expense, but what that really means is as long as it's for the individual's benefit, it's going to meet the qualified disability expense. Like, for example, the regulations say rent and food are qualified disability expenses. A vacation is a qualified disability expense if it benefits someone socially or emotionally. So as long as you can tie some benefit back to why this would enhance their quality of life due to their disability, it should be a qualified disability expense. Lastly, where does the money go after the beneficiary passes away? Like the first party special needs trust, the state is paid back for Medicaid benefits if there's money left in the account when the individual passes away. So again, an ABLE account, these came about by federal law several years ago, but really because with a special needs trust, before ABLE accounts, the only way to make money invisible were these two special needs trusts. And the problem with those trusts is that the money is managed by someone else as trustee. And so there was a big movement, especially among disability advocates, to say, we really should have an option where if the person with the disability is able to, they can contribute their own money and still manage it themselves. And that's exactly what the ABLE account permits. So it's an alternative tool. Sometimes people, if they have extra resources and they're $16,000 or less, they can put them in an ABLE account and they don't need a first party special needs trust. So a first party special needs trust today, I find, is usually when somebody needs to make, in two situations, someone needs to make a big sum of money invisible, more than $16,000 in a year. Or number two, an individual is over an income limit for a program. You can't use ABLE accounts if you're over income, only if you're over assets. So that would be another case where I see those first party special needs trusts still used today. And that is the presentation. So back to the list of questions.
Okay, before we get to the questions, I'm going to launch a poll. Please do answer the poll. So while everyone's answering questions, they can also answer the poll questions as well. I appreciate that. It does give us important feedback. Okay. Okay. There's many questions. Go ahead.
In the first party trust, is the individual with the disability who opens the trusts or the parents?
Great question. So for a first party trust, there are many different people that can open it. One is the individual with the disability. One is a parent, a grandparent, or a court. So basically, if somebody is appointed through the court to make decisions for that individual, they can open that trust with the court's approval.
And another question related to the trust, third-party trust rules again, if when a will, is the trust already exist or does it begin upon my passing?
If it's in your will, it's going to be funded when the individual passes away. So it's only operative when the person whose will it's in has passed away. And it's going to be subject to the court's oversight throughout that individual with a disability's lifetime. If you want to establish a trust that can be valid and operable during your lifetime, it would be a separate document outside of your will.
Okay. And then one, if you want Dds Services with IQ above 69, you need one of those tests, GFS, ADOS, accepted by the DDS. You should apply for the DDS Autism Waiver as soon as possible, as you go to the waiting list as the date of application.
I think was that a statement or a question?
Looked like a statement, but it was a question too, like if the IQ if you want to apply for the DDS service, the IQ above 69, do you need one of those tests? GFAS or ADOS?
I don't know what that first acronym is. ADOS is an autism test. So if you're trying to apply for DDS services, you need, so it's the same application. So DDS has an application form that is either used, you either fill it out because you have an intellectual disability or autism, and it's the same application paperwork, and it tells you exactly what testing you need for either intellectual disability or for autism. So if you want to be classified as having an intellectual disability, you would submit those tests. If you feel that you're not going to meet that eligibility criteria and you want to apply for autism, then you submit those tests. But I do agree with the statement that you should apply for those autism services as soon as possible so that you get yourself on the waiting list.
Okay, let me see the next one. We got a special need trust done in a state of VA. Do you need to have it done all over again here, or you can just transfer to Connecticut?
So a third-party trust was established in Virginia. I would say that anytime I draft a special needs trust and I know my client, they say we might move down the road, I always recommend that you have an attorney in that new state review the trust just to make sure that, in their opinion, it matches what the state would view as being a valid trust, although it should still be valid in Connecticut as long as it was valid and correct in Virginia, because special needs trusts are really, third-party trusts are based more on federal law than state law. So the state that you're in shouldn't make a difference. But I always just say it's always a good idea to have an attorney in your new state to review it, because there might be certain rules that would impact them differently in that state, including disclosing the trust. That's a rule of Connecticut, is when and how to make disclosures of your trust. So that's just a good conversation to have with a local attorney to make sure that they have kind of done everything that they need to do with that trust.
Okay. Is the ABLE account a good idea to have if a SSI money accumulates over time, if the individual can't expend the money down?
Yes, that is probably the best use of an ABLE account. Anytime somebody's applying for SSI, I generally recommend that they open an ABLE account for that very reason, so that the individual, if they're accumulating that $841 a month, or whatever might be left after they're paying rent every month, that they're able to keep above and beyond the $2,000 resource limit in the ABLE account. So that is a perfect use.
Okay, it is possible to have both Medicare and Medicaid, and it's worth to have Medicaid for the CFC supports. Does Medicare provide any in-home or PCA help long-term, or do you really need Medicaid for that?
Great question. So Medicare is a source of health insurance, as is Medicaid. And when someone has Medicaid and Medicare, if you go to the doctor's office, you give them both your cards, they're always going to bill Medicare first, and then Medicaid is going to always be the last card that they bill if Medicare isn't accepted. So that's from a health insurance perspective. So you can have multiple insurances. From a services perspective, Medicare is not going to provide long-term services and supports. They provide very limited services for very short windows of time, usually if you've been hospitalized for a period of time and then you're in a skilled nursing facility. And the maximum period that they cover is generally up to 100 days. So if someone really needs day-to-day long-term supports, you're looking at Medicaid and not Medicare. But you can have both. It's just a matter of which insurance is doing what.
Okay, I do have a question. Are there programs that can offset attorney fees when establishing a first or third party trust?
programs. I think that's something you'd have to speak with an individual attorney about. Different attorneys set different, work their fees differently. It's possible that there are attorneys that in legal aid or who would do pro bono work for special needs trusts. So you can always contact legal services if you're in a situation where the fees might be a barrier.
You have another one, Laura? Can I ask the next one?
I know there's a couple people with their hands raised too, and I want to get to them as well. Is there a
There wa-
ceiling? Is there a
there wa-
ceiling for an ABLE account? I thought it was $16,000 per year.
Yes, it's $16,000 per year from all sources. If the individual is working, there are some additional contributions that they can make if they're not contributing to a retirement plan through their employer. But 16,000 is really the rule.
I have one that I think is the lady that has the hands up. I'm gonna read. If it's a different one, she can maybe say something. If the individual is someone with autism, high functioning, and he wants to take over the trust, how can he remove the trustee?
You'd have to look at the language of the trust, but usually a beneficiary does not have the authority to remove a trustee of a special needs trust. However, if they have some concern that there's wrongdoing, but on the part of the trustee, they can certainly go ask for the probate court to become involved to review what the trustee is doing.
One here, like in a scenario where the disabled person is paying rent to the parents to fully qualify for the SSI benefits, can the rental payment be deposited into the ABLE account so the money is ultimately available to the person with the disability?
Yes, and that is something that parents often do. So the way that it works, and sometimes it's even a step further, that the parents put money in the ABLE account, the child takes the money out of the ABLE account and pays it to rent as the parent, pays it to the parents as rent, and then it kind of circles back and forth. So yes, it is permissible for parents to accept rental payments from their child and then put them into the ABLE account, because really once they receive the rent, it's their money and they can choose to do with it what they want. If they choose to put it in the ABLE account, that's permitted.
Would you recommend having trust removed from will so it can be managed by the trustee?
So when a special needs trust is in a will, it would still be managed by a trustee, but it's going to be subject to the court's oversight. So I say it depends on what the person's goals are. I would say 9 times out of 10, the clients that I work with don't want the court oversight of the trust, but there are circumstances where people do want that oversight. So it's just going to depend on their personal preferences.
And one more is Charlene said her husband has a question, but it's too long to type. I don't know if they want to unmute it and ask the question. Charlene,
Yes,
you were
yes.
next on my list.
Yes, thank you. My question is concerning first person and third person trusts. If it's better to have the trust not connected to the will, and we were looking at a third party trust or a third person trust. If death benefit payouts from a life insurance policy are going to get paid into the trust after we die as our son's legal guardians, does that require it then to be part of the will? So that the will directs that those benefits go into the trust, or can that be handled separately also?
Great question. So the special needs trust can be funded in a couple of different ways. With a life insurance policy, what you generally do is create the third party trust, and then you'd update the beneficiary on the life insurance policy. So let's say it's a second to die policy. It would say that upon the death of you and your spouse, the proceeds would be payable to the trustee of the so-and-so third-party supplemental needs trust, and that's how it would get there. As for other assets that would be passing possibly through your will, you do the same thing, so that instead of naming your child as a direct beneficiary, so let's say your child's name is Harry, instead of saying 50% of my estate goes to Harry, you'd say 50% of my estate goes to the trustee of the Harry third-party supplemental needs trust. So you've named the trust in your will, but the trust is actually a separate document.
Got it. Great. I understand very much.
Good, good, you're welcome.
Just one more. Well, I thought
Nope.
it was one more, and another one pops up. Can we add a clause into the trust specifying that at 25 years old, if her son is independent, the trust will be canceled?
I wouldn't draft a trust that way. As I mentioned, you can do, I don't know if the answer, I don't know if other attorneys would give the same answer, but my answer is, if a trust is going to automatically terminate and the property is going to automatically go to the child with a disability at a certain age, my concern is that the state is going to say, this isn't really a special needs trust. But what you can do is you can say that you want that this trust has an early termination clause, and that the trustee can evaluate at any age, including the age of 25, whether the child is independent, whatever the factors are that you want to put in there, and then give it to the trustee in their discretion to terminate the trust, as opposed to saying this trust shall terminate. Making sure that the trustee always has the ability to make a choice is really important from my perspective, because if you draft a trust in a way where certain things automatically happen to the benefit of the individual with a disability, you're starting to take away some of those properties that make everything invisible. And I just don't like playing on that line. So I would say there are ways to accomplish that goal, but I don't necessarily know I would phrase it in that same way.
I see one more question in the chat. My child is turning 18 years old soon and is currently receiving Ssdi dependent benefits. What happens when my child turns 18 years old to their benefit? My child will still be full-time student for the next 2 years. The parent is disabled. The child at this point, there is a plan down the road to file for disability for the child behalf, but not before age 18.
So when the child turns 18, you would apply for the Social Security benefits at that point in time. And then what I anticipate would happen is the dependent child benefit would turn into a disabled child benefit. So it would turn into that Ssdi benefit.
Thank you. You see any other questions, Laura? I read, I think, all the in the chat. I try not to miss anybody, but I think I ask it all.
No.
I have one question. I wanted to know if I could be, I'm the parent that needs to do an appeal for SSI. My son he has an intellectual disability, and I was denied. So I know that you said earlier that you could put me in touch with an attorney that could assist me with the appeal process.
Mm-hmm.
So should I just call you at the contact number provided, or?
Yes, you can either call or email me, and I'm happy to connect you with them.
Okay, thank you.
You're welcome.
Are there any other questions? I want to thank everybody for coming, and our next Transition Tuesday will be March 8th and we will be discussing transition to adulthood and employment services and how it all relates to special education and the IEP. We will be doing that presentation in Spanish the following week on March 15th. So thank you, everybody, for joining us.
Will the PowerPoint be shared via email to the group, or how will that be posted?
Is that something you're okay with, Kathleen?
Absolutely, yes.
That'd be great because it has
Yeah.
the details that were
It does.
spoken about.
It does.
Yeah,
We
I
will
would
get
like
that
that.
out.
Yeah, thank you.
Absolutely,
So how
we
will
can
that
email
be
it.
available?
I can email it to you.
Oh, wonderful. Thank you
Great.
so much.
Yes,
All
I
right.
think
Thank you,
that's
Kathleen.
Laura, if you can make it a PDF,
Yes.
Yeah.
perfect.
That'd
Yeah.
be great.
And actually, I'll drop it into the chat just to see. Hopefully, it'll work. Sometimes Zoom is a little bit picky.
Mhm.
Okay. So
If
if you just give
people
me.
ask for her phone number, the Catherine, if you need your phone number.
It's on the PowerPoint.
Oh, it's in the PowerPoint. I didn't pay attention to that detail. I was so busy with well, all right, thank you.
Okay, so it will be emailed to us, the PowerPoint, because I need her contact info. Will the PowerPoint be emailed?
Yeah, she's trying to put it on the
Oh,
chat
oh,
link.
okay. Thank you.
I'm
have
also
to
just
say-
putting my phone number and my email. in
Thank you.
Thank you so much, Kathleen. This has been so extremely helpful. I
You're
can't
so
tell
welcome.
you
Oh,
Thank
good.
you.
because you
It's my
explained it
pleasure.
so clearly.
Oh, thank you. That really means a lot to me. That's always my goal, is to break it down. So thank you for that feedback.
I appreciate it, and I know many people do as well.
Thank you.
Yes, thank you, Kathleen. That was very helpful. You did a great job.
Oh, thank you. Thank you very much.
Thank you.
Thank you for this.
Thank
Fantastic.
you, Laura.
Thank you.
Absolutely. It should be in the chat. And again, we will email the PDF and it will be translated into Spanish shortly. So thank you, everyone, for coming.
Thank you. Good night.
Thank you.
Thank you.